Good morning, everyone. Good morning, Advocate Batoyi.
Good morning, Judge. Good morning, all.
Good morning, Advocate Chauke. Good morning. Our apology for a delay. Mornings are a bit difficult after a long week. We also acknowledge that it has been a long slog for you, Advocate Batoyi. At least today is Friday. We will all pause a little early by lunchtime, as we do counsel. We should acknowledge that it cannot be easy for you being on the witness stand for a long time. But thank you. We are making some progress, and we hope that Advocate Nkabinde, we would finish with Advocate Batoyi's evidence before we go on recess. Hopefully, without being directive, but let's see how far we go.
Thank you, Madam Chair. I get the message.
Advocate Batoyi, you are still under oath.
Noted, Chairperson.
Thank you. You may proceed, Counsel.
Thank you, Madam Chair. Advocate Batoyi, I want to move on to a different topic. You mentioned a few times that out of all of the cases, the one case that was prosecuted resulted in an acquittal, correct?
Yes, that's correct.
Now, that case was the case of Nkabinde, which is recorded as CAS 03/04/2010, correct?
I can't recall the CAS number.
Okay, well, I can help you. If you can go to file 3, page 74.
There's one and two. You can keep on that side. Thanks. $374.
Page 74 at file 3. That is the statement of the mother of Kwazindlovu, who was killed by Warrant Officer Padeache. And there is a case number at the top.
I see that.
So do you accept that the one case that was prosecuted that resulted in an acquittal
I
is
accept
that
that.
case? Yes. Now, the statement of the mother starts at 74 to 79. Is that correct?
That is so.
The statement of the father,
I beg your pardon, is the name there?
yes,
The
Lindy where Desrin Ndlovu.
Desrin Ndlovu.
Yes,
Is that in Ndlovu?
yes, Ndlovu.
Yes, thank you.
Yes. Lindy where Desrin Ndlovu. That is the mother of Kwazindlovu, the 16-year-old boy. The statement of the father, Sibusiso Wiseman Ndlovu, starts at page 80. Until page 87. Is that correct?
That is so.
And a supplementary statement from the father, Wiseman Sibusiso Ndlovu, is at page 88.
That is so.
Yes. Now, I just want to understand the reason why you've singled out this case as the only case that resulted in an acquittal. Is it to say that it proves that you were right in the withdrawal of the cases, or it proves that the DPP was right in the withdrawal of the other cases?
It's just a fact.
Okay. It's a neutral fact. It doesn't prove anything.
Well, they were declined, the DPP declined and prosecuted this case, and there was a withdrawal. That's a fact.
I don't think you're answering me. I was asking for the reason why that fact was important for you to repeatedly mention. Is it because it supports your thesis that there was no evidence, or it was just a neutral fact?
It's a fact. You can make what you want of it.
And you will not answer why you thought that fact was important to be mentioned.
There's lots of facts that I've mentioned. Some are important, some less important.
I'm not asking you about other facts. I'm asking you about this particular fact. You will not answer why you thought that fact was important to mention or not.
I think it's part of what happened in this matter. It was important that I gave the complete picture.
Now, what you did not disclose in your alleged complete picture is that the mother of Mr. Ndlovu, through Miss Mary de Haas, complained bitterly about the conduct of the prosecutor in suppressing evidence. You remember that complaint?
Mary de Haas has written a number of letters to me. I can't recall one specifically about this matter.
I don't understand that. Ms. de Haas was always assisting the mother of the child, Mrs. Lindiwe Ndlovu. She wrote to you complaining bitterly about the conduct of Advocate Sankar, in which she stated that Advocate Sankar was guilty of dereliction of duty, guilty of suppression of evidence in the way that case was prosecuted. You say you don't remember that.
I'm trying to think back. I think you are right. There was a complaint about this, which I forwarded to the DPP, who inquired into the matter and found that there was no improper conduct, if I recall correctly, on his part.
Can you just explain to...
Before you do that, Counsel, who is Advocate Sankar?
Advocate Sankar was the prosecutor assigned to prosecute this case.
The Isikaweni matter.
The Esikaweni matter, which was a murder charge against Warrant Officer Padayachi.
And the answer, Advocate Batoyi, is that the matter was forwarded to the DPP. Would it have been the DPP KZN, and who was that?
That's correct. It would be Advocate Elaine Zungu, sorry, now Harrison. Advocate Elaine Harrison.
I beg your pardon?
Advocate Elaine Harrison.
Elaine Harrison.
Now,
Thank you.
I'm not yet there, Advocate Batoyi. I am still on the question of non-disclosure. Why have you not disclosed that there was a complaint of suppression of evidence against the prosecutor who prosecuted this case?
It wasn't, I didn't mean to withhold evidence. It's just something that I didn't think about. It's not non-disclosure. I've got nothing to hide with that.
Yes. The problem with that statement is that yesterday you were going on about justice for victims. You've repeatedly mentioned that the only case that was prosecuted resulted in an acquittal, any sensible person would have thought that a complete picture would oblige you to disclose that there was a complaint of suppression of evidence against the NPA's prosecutor.
I can't recall what exactly the complaint was, but I didn't intend to withhold anything or not disclose it for any reason.
That's why I'm asking you for the reason why this was not brought to the attention of the panel. You say it was not your intention to withhold it, but as a fact, you never told the panel. If you read your statement under oath, your statement simply blithely says the one case that was prosecuted resulted in an acquittal, never actually engages with the complaint that came afterwards.
The matter was dealt with. I didn't intend to withhold it, any evidence. It just didn't occur to me at the time that it would be relevant in this context.
You say that it's because you did not think it was relevant.
In this context, yes.
Now, if you go to page 154 of file 3, that document is the complaint by Mrs. De Haas on behalf of Mrs. Ndlovu, the mother of the child.
I see that.
Document, is that
Page 154, Madam Chair.
154.
154
I beg your
of
pardon.
file
I
3.
beg your pardon.
At paragraph 2, this is what is stated. Under A of my letter of 18 November 2022, I criticize your failure to prosecute members of organized crime in what became known as the Katomano Squad for killing Kwazindlovu, a child asleep on a sofa in his own home, despite the evidence available to the prosecution. This was a particularly heinous crime, and when, after a very long struggle on my part on behalf of the heartbroken parents of the child, there was a prosecution, it was only one member, a certain warrant officer Padayache, when it should have been common purpose. You see that?
I do.
Padayache had for years stood accused of serious crimes in the Umbilo area, Durban, including drug running and murder. But had I known the cruelty I would subject the parents to at the hands of the prosecution, I would not have motivated for a prosecution, since I believe that justice was deliberately defeated. Now, I stated to you at the beginning that your prosecutors stood accused of defeating the ends of justice. You said you did not remember that. Do you now remember it now that I'm reading it?
I do.
Yes. Then she continues, the case should have been held in Mbangeni Regional Court, where the parents live. But they were made to travel to and from to Durban on a daily basis without the support of family and friends, because the SPP advocate, Sankar, that is where the name comes from, Madam Chair, said that he needed an experienced magistrate available to Durban to hear it. And you see that here, what she is talking about is the inconvenience placed on the poor parents of Kwazindlovu, having to travel long distances without the support of the state. Correct?
I see that.
Yes. Then it continues. The magistrate who had it was acting. However, Sankar's failure to use the reports we had provided him from the three experts, the late Frank Dutton, top pathologist Dr. Steve Naidu, and top ballistic expert Cobber Stale, I believe constitutes defeating the ends of justice. Now, I said to you that your prosecutors were accused of suppression of evidence. Remember that?
I do.
Yes. Then it continues. Hardly any witnesses were called and cross-examined. I may take my complaint about Advocate Sankar, who went out of his way to persuade the parents to settle for an inquest, despite there being all the evidence needed, which he did not use to prosecute further. Can you just explain to me, when it was stated to you that Advocate Sankar had tried to force the parents to settle for an inquest,
The DPP to look into the matter.
I'm asking about yourself. Why did you not intervene as the NDPP?
That is my intervention.
We don't even have any letters, any statements from you to the DPP in this record because of your decision not to disclose these facts.
It was not a decision not to disclose these facts.
Well, I thought you said you considered it irrelevant. I would regard that to be a decision.
It was not a decision not to disclose these facts. The matter didn't come up.
Yes. So you are saying to me, a parent of a child who has just been killed by the police writes to the NDPP and says to you, your prosecutors stand accused of defeating the ends of justice because they have suppressed evidence and they've tried to force the family to settle for an inquest. The only intervention you can make is to refer it to the DPP.
That is a very serious issue. And of course, the first step is to ask the DPP to look into the matter, which is what I did.
Is there any report from the DPP that exists in your office?
There should be.
Is there any independent investigation that was conducted in this matter?
There wasn't.
There was no independent investigation.
There was no independent investigation.
Just explain this.
And I beg your pardon, and this DPP you are referring to is the same Madam Harrison?
That is correct, Chairperson.
Why did you not call for an independent investigation? This is, your prosecutors are accused of committing crimes.
The DPP looked into the matter and sent me a report on the matter. And I can assume that because of what she said in the report, we didn't consider it necessary in the circumstances.
Well, I don't understand that. A prosecutor is accused of defeating the ends of justice. It is brought to the attention of the NDPP. The NDPP fails to conduct an independent investigation to verify what transpired and comes to an inquiry and says she's basing her answers on an assumption. Is that what you want us to believe?
No, I'm saying that I referred the matter to the DPP, who looked into the matter and provided a report on it.
I think we've moved past that stage. We know that you did so. I'm asking you about why, when your own prosecutors are accused of effectively throwing away a case, you don't subject that to an independent investigation.
The first step is to ask the DPP for a report. And depending on what's in that report, we consider whether further steps are necessary. In this particular case, I am assuming, because I don't have the report before me, that on the basis of that report, no further steps were considered necessary.
Well, I would imagine you would remember this because The letter is dated the 12th of December 2024. It's a fairly recent occurrence. You would know why you elected not to conduct an independent investigation, despite the grave accusation brought to your personal attention by a grieving parent.
I can't say now.
You can't say.
No.
Then it continues. I believe that the blame for effectively defeating the ends of justice is a collective one, for which the prosecuting authority is responsible, because it had fought tooth and nail against the prosecution from the time the child was killed, with the exception of when top Hawks members and the prosecutors from other provinces arrested those who had been killed. Having gone through the sham of a prosecution has traumatized the parents of the boy further, especially as, to rub salt into the wound, the police had claimed at the time of the killing that the child was a criminal, and their funeral policy holder refused to cover the funeral costs on the basis that the police had said he was a criminal. It is clear from character references from his teachers that he was a quiet and it is clear from character references from his teachers that he was a quiet and a well-behaved boy. So in addition to inflicting secondary victimization on the parents, they have engaged in character assassination of a child. Just tell me, do you honestly believe that the actions that you took to inquire into a travesty of justice as alleged were sufficient for you as the NDPP?
This is a matter when all of the dockets came back to me, all the murder dockets. This is the one that I questioned, because I looked at the docket and the evidence in this matter, and initially there was a decision not to prosecute. And I sent it back and I said, look at this more carefully. I can't recall the detail, but I sent it back to the DPP to reconsider the matter, saying that I thought that this matter should be prosecuted. And they did reconsider the matter, and the DPP decided to prosecute in this matter.
I don't think you're answering my question. I'm talking about the complaint that came thereafter, that the prosecution was intentionally botched. I'm asking you if you honestly believe that your reaction of handing this to the DPP, not even knowing what the DPP said and why there was no independent investigation, do you honestly believe, sitting there as the NDPP, that that was sufficient?
I do honestly believe that that was sufficient in the circumstances.
Even though you don't even know why no independent investigation was held?
I can assume that it's on the basis of the DPP's report that that was the case. Because if there was anything in that report to suggest otherwise, we would have had an investigation.
But you don't even tell us what that report said.
I can't, because I don't have it in front of me. But I do have my letter, which is in your
I'm
bundle.
coming to your letter, and you are running ahead of yourself. I'm still asking you about your evidence that you gave this to the DPP. I'm asking whether you honestly believe that where your prosecutors were accused of intentionally defeating the ends of justice, that was sufficient.
I do.
Yes. Then the writer of the letter continues. I have lost count of the cases in which I have helped parents to try and get justice for children killed. But this is the worst case I have ever experienced, thanks to the National Prosecuting Authority, for which you bear responsibility. I hope that all of you who are complicit in this travesty of justice will experience at least twinges of conscience. Now, you then submitted a response, which you've been keen to move towards.
No, I just mentioned it was there.
Yes, well, that's what I am going to ask you. This document here, this letter, was submitted by us we received it from external witnesses who watched your evidence, and they were horrified at the fact that you claimed that there was an acquittal on Mr. Ndlovu, on Kwazi Ndlovu, but you never disclosed that you yourself were made aware of the suppression of evidence. That's why it's there. It's not been brought there by you. It's been brought here by Mr. Chauke because people approached him and were horrified at your evidence. Can you explain why is this letter introduced by Mr. Chauke and not by you?
I mentioned earlier, and my response remains the same. There was no intention to suppress anything.
Advocate Pato, you must have mentioned this acquittal at least 3 times. It's in your statement, so it's something that was uppermost in your mind.
It wasn't uppermost. It was one of the facts relating to this matter. It gave the full picture. That was all.
An accusation that a prosecutor has thrown away a case will not be uppermost in your mind.
It is a very serious issue, and it will be.
This is why I am saying you had a duty to disclose it. You were intentionally withholding it from this panel.
That is not the case.
Now, we can then go through this letter, which you suppressed.
If I may just recap, what answer did you give Advocate Batoy as to why this letter was not brought to our attention by the evidence leading team?
Chairperson, I said that it's not something that I thought about. It wasn't intentional in the sense that we wanted to suppress it.
This is despite what you've just said, that it is a very serious matter.
It's a serious matter if a prosecutor is accused of attempting to defeat the ends of justice.
However, nonetheless, consider that it is not a matter that you thought was not necessary to bring forth.
I didn't, Chairperson.
Thank you.
Just one question, Advocate Batoy. If I understood this letter correctly and I was listening attentively, the reason, one of the reasons for the matter to be referred to, is it Durban? Yeah, to be referred to the place where it was to be tried, was that the magistrate that would be presiding over the matter was a magistrate with experience. Is that correct?
I see that in the letter, Chairperson.
Yes, the
I
letter
don't know.
says one of the reasons was that the magistrate was an experienced magistrate. One of the reasons.
I see
was
that in the letter, Chairperson.
And then further on, the letter says that that was an acting magistrate.
I see that as well.
You see that.
Mhm.
And this came to your attention when?
In December last year.
In December last year. And okay, that's fine. Thank you.
Thank you. If I can look at your letter in some detail now, you would accept that even though you will refer to the report of the DPP, that report was never finished to Mr. Haas, who was representing the family. correct?
That is correct.
Yes. Your letter also does not respond to the to the serious claim that the prosecutor attempted to force the parents to settle for an inquest instead of a prosecution. There's not a single line there that responds to that issue.
That is so.
Which makes me believe that the report you received that you purport to be relying on also did not deal with that issue of attempting to force victims of crime to settle for an inquest.
Possibly.
Why not? Why don't you address the allegation that there is a prosecutor who's forcing the parents of a deceased child to settle for an inquest?
I can't answer that question because if it's true, it's a very serious issue. Initially, there was a decision to hold an inquest in this matter, which was overturned.
I'm not asking you that. I'm asking you the accusation against your prosecutor is they were forcing the parents, attempting to force, not forcing, the parents to settle for an inquest instead of a prosecution. You claim that is a serious matter. It is brought to your attention. It is not dealt with by your DPP. You also not address it. I'm asking you why.
The matter did proceed to a trial. That's the only reason I can think of in terms of why that matter was not dealt with any further, that decision was changed.
I'm asking you about the conduct of the prosecutor. Remember that you are the one who brought an issue of conduct of the prosecutor to this panel. I'm asking you, there's an egregious claim brought to your attention of an attempt to force an inquest on the parents. Why have you not made any inquiries about the conduct of the prosecutor?
I can't say anything more than I've already said on this matter.
So you don't know why?
I can only imagine it's because the matter did proceed to trial.
That is just your imagination.
Assumption.
It's just your assumption.
Mhm.
Yes. Now,
The assumption that the matter was eventually tried?
No. That nothing further happened because the matter went to trial.
Okay.
yes. Now, if you turn the page to page 160, in the third paragraph, there you say, Advocate Sankar consulted with Mr. Stale and Dr. Naidu. Now, Madam Chair, Mr. Stale was the ballistic expert.
Tell us first what this letter is. That part of 160 is part of the letter by?
This is the letter. If you turn to page 161,
Yes,
it is a letter signed by Advocate Batoy directly
thank you.
to the parents via Mr. Haas, explaining herself on the allegations of prosecutorial misconduct that were alleged against Advocate Sankar.
Thank you. Thank you.
Thank you. Now, one of the points you make in the third paragraph is that Advocate Sankar consulted with Mr. Stale and Dr. Naidu, and both considered during the thorough consultations that they were unable to answer the single question whether the deceased was armed with a firearm when he was shot by Warrant Officer Padayache beyond a reasonable doubt. Do you see that?
I do see that.
Can you just stick for now to the consultation with Mr. Stale and Dr. Naidu? There was another ballistic expert by Colonel Mangena in this case. Do you remember that?
I don't.
You don't? Okay, let me show it to you. If you go to file 1, Madam Chair, I'm just waiting for my junior to show me the page.
Which letter?
There is another report by a ballistic expert. Actually. Page 367. That should be file 2. Sorry, it's file 2 actually. No, it's because this ends at 331. Yes, it's perfect. Yeah, perfect. This is the one. Yes. Uh, 367 file 2.
Sorry, what's the number again?
367 file 2. So you will see that is an expert affidavit of Christian, I think he Captain Christian Mangena in this Escawen case 0304-2010. Correct?
That is so.
Yes. Now, the advocate who ran this case, Advocate Sankar,
Pardon, Counsel, I'm sorry to interrupt you. That seemed to be a continuation from (458). Is that document?
no, Madam Chair, are you at 367?
Or 3? Oh, I'm sorry. I was looking at 467.
No, I understand.
I'm sorry.
Yes.
I'm sorry. My apology.
Yes, thank you. Now, Advocate Batoy, the advocate who was assigned to hear the matter, to prosecute the matter, Advocate Sankar, appears not to have consulted with Captain Mangena. Is that correct?
That is so.
Do you know why?
I don't.
Did you ask why?
I didn't even know that this was a witness in this matter at the time.
You didn't know that Christian Mangena was a witness in the matter?
I didn't know that there was another ballistics expert in this matter.
This is, for me, very strange. We got this ballistics report from the dockets that you sent us. How can you not know that there was this report?
At the time that I got the report from the DPP, I wouldn't have had the docket. I would have had no knowledge of what was in the docket.
Well, this was in December 2024. These dockets had been with the NDPP's office since 2019.
Counsel, are these part of those 23 or
Yes.
the dockets that you spoke about earlier?
Indeed. So this is an extract from that docket.
Yes. In fairness to Advocate Batoy, she made it clear earlier that she'd never read those dockets.
No, I'm making a different point. That this particular case is brought to her attention on the basis that the prosecutors have thrown the case away because they failed to call relevant ballistic reports. That is the point I'm making. She has responded in a letter in full, trying to justify the misconduct. This is the only point I'm making here. I understand the general point that she never read the dockets. Advocate Batoy, I'm sorry we have to deal with this point again. I am asking you the question
Excuse me.
around the failure to consult Captain Mangena, who was a ballistic expert. My understanding is that your answer is you don't know because you did not even know that there was another report.
I was not aware at the time that there was another ballistics expert.
Yes. Now, let's look at what he says, this ballistic expert. At page 382. These are his conclusions. After examination of the crime scene and observation of the crime scene photos and post-mortem, I am of the opinion that 12.1, the deceased here is the 16-year-old boy who was watching football. The deceased was hit by at least 3 bullets. 4 fired cartridge cases were collected from the crime scene, means 4 shots were fired and 1 bullet missed him and perforated the sofa at hole marked W2. That's the first. 12.2, the bullet that perforated the right arm of the deceased at wounds 3A and 3B also perforated the sofa at hole marked W1. 12.3, looking at the position of the deceased, I am of the opinion that wounds marked 2A and 4A were inflicted by the same bullet. And 12.4 is important. It says the bloodstain pattern on the back of the sofa next to the right arm of the deceased is classified as forward spatter. This pattern is caused as the bullet exits the target and a larger amount of high force impact spatter is directed in the same direction as the bullet. The amount of high force spatter created will depend upon the caliber of the bullet fired. The bigger the caliber, the greater the spatter. The positions of the spatter and the wound sustained indicate that the arm of the deceased during the incident was almost positioned where it is current positioned. There was a slight movement of the arm after the incident. Now, this is a case where the policeman claimed that this young man had a gun and was trying to shoot at them. The picture he's analyzing there is at 385. Can you turn to that picture? Now, he says after the analysis of the sheer velocity of the bullets, he came to the conclusion that the position of those arms was where it is at the moment, and there was only a slight movement. Can you see that?
I do.
Yes. But he says that slight movement was after the incident. Can you see that?
I see that.
Yes. Then he continues. The injuries and damages caused by all 4 bullets had characteristics of high velocity bullets. This is most probably 5.56 millimeter caliber bullets, supported by a number of fired 5.56 times 45 millimeter caliber cartridges. Now, other reports say that those bullets are only shot by R4s and R5s. Those are machine guns. Do you know that?
No, but I accept it.
But they also say what those bullets do, the 5.56 caliber bullets, explode inside the body of the victim. Do you know that?
I'm not aware.
And that is why the experts then say, when you use this type of a bullet that is intended to turn and explode inside the body of the victim, it is only consistent with the intention to kill. Do you know that?
I'm not aware of that.
It is expressly not consistent with an intention to arrest a suspect. Do you know that?
No, I'm not.
Now, Captain Mangena continues at 12.6. Looking at the wounds sustained, the blood-stained pattern and the bullet holes, all these confirm that the deceased was shot while in a lying position on the sofa. Now, we know that lying position because we have page 385. The expert is explicitly clear that his opinion is that this young man was shot while lying on a sofa. Do you have any comment on that?
I see that, and it is very concerning that this witness expert was not consulted. I agree with that, and was not called at the trial.
Advocate Batoy, it's no help for you to be concerned today when this was brought to your attention in December 2024, that here is an expert report, it is in the docket, your prosecutors don't consult with him, he is not called as a witness. So to come after the event and to say you are concerned about it really helps no one, because the parents told you this. But then there is a further problem at 12.7. They say the current position of the deceased shows slight upward movement of the left arm, and the position of the firearm is unexplainable. We can go back to page 385. This is why it was concluded that that firearm was most probably planted by the killers of this young man.
What does that mean? That it was planted?
That it was put after they shot him. I know planting is a slang. But that firearm was put there after they shot this young man.
Any comment?
Chairperson, all I can say is that, I must accept this expert's evidence, and it is very concerning that this particular expert would not have been led at the trial.
Well, sorry, Advocate Batoy, it's not about not leading him at the trial. They did not even consult with him
That is correct.
to understand that there are weaknesses in his evidence, etc.
That is correct.
But
And that is also very concerning.
But the report is in the docket.
As I mentioned, I was not aware of that.
And this is why your conclusion that focuses on the opinions of Mr. Stale and Dr. Naidu completely misses the point.
I agree with you now that I'm aware that there was another ballistics expert.
And this is why, if you look at 1, 2, 3, 4, 5, on the 5th paragraph, where you talk about
Sorry, what page are you at again?
page 160 of your letter, the 5th paragraph,
Yeah, got it.
when you are telling the parents that these experts were expressing an opinion based on the position of the firearm in the photographs, that is just wrong, because the conclusions are not based on the positioning of the firearm. We've just looked at all of the 7 conclusions. The firearm is only mentioned, the position is mentioned once at 12.7, page 382, as unexplainable. The rest of the opinions of Captain Mangen are based on a detailed analysis of the crime scene.
I see that, and I agree with you.
Now,
The specific paragraphs on page 160 would have been what you referred us earlier to, the 3rd paragraph and the 4th paragraph, I suppose.
1, 2, 3, 4.
Which-
The 5th paragraph, Madam
the
Chair, that's the one I was talking
the
about.
suspicion,
Yes, yes.
the suspicion.
The real point here is that Advocate Batoy concluded that the reason those witnesses were irrelevant is because their opinion was based on the positioning of the firearm. But that is just wrong. When you actually read the opinion of Captain Mangen, the firearm positioning is mentioned only once. The opinion is based on an analysis of the crime scene as a whole.
Thank you, Councillor.
Advocate Batoy, you can respond to that comment.
Yes, all I can say at this point is that it is extremely concerning that this, because as I said, this was a matter that I referred back to the DPP because I thought that it was a matter that needed to be prosecuted. The DPP reconsidered the matter, prosecuted the matter, but it is now concerning to know that there was another ballistics report and that this expert was not called. And I certainly won't leave it at that. It's after the fact, but it's something that I will need to look into.
Now, there is a further problem with your letter, which says that the reason Mr. Stale and Dr. Naidu were not called really revolves around the positioning of the firearm, which is what we have looked at, the 5th paragraph of page 160. It makes me believe that you did not read even the opinion of Mr. Stale and Dr. Naidu. Did you read it?
I didn't read anything. I said I didn't read the dockets.
No, I'm asking about the specific,
I did not.
because we asked for this opinion. Madam Chair, it is at file 3, page 90. Page 90, file 3. Now, my concern here is that in the 5th paragraph, that these witnesses couldn't give evidence beyond a reasonable doubt about the positioning of the firearm as the only basis to draw from those reports shows to me it can only have been made by a person who did not read the actual report of Mr. Stale and Dr. Naidu. That's why I want to go through this report with you. If we start at page 91, under E, main factual findings. Sorry, I'll go to that. I just forgot there was a question I had to ask before this. Advocate Pato, you know, this report that we are dealing with was not in the docket. Did you know that?
No, I'm not aware of that.
We received this again from third parties who were horrified at the evidence you were giving when they were watching it on television. Why would a report like this not be in the docket?
It should be in the docket.
But
I can't answer that. It should be in the docket. Unless there's been some reason to suppress evidence, it should be in the docket.
well, this is the whole point that was made, that this case has been intentionally botched. You are talking about this report because we assume when you say Mr. Stale and Dr. Naidu, the only joint report that we could find is this one, but it was not in the docket that you disclosed. We found it from third parties. Now, what they say here at the main factual findings under E1-2, Kwazi was 16 years old and in grade 10 at school. When the father retired to bed between 10:30 and 11 p.m., Kwazi was still watching soccer on television. The yard outside had 3 vehicles, a white Mercedes-Benz used by Mrs. Ndlovu, a red BMW used by Mr. Ndlovu, and a third vehicle, Baki, belonging to a friend of the family. Whilst both parents were fast asleep, there was a violent and a sudden loud sound early in the morning as the kitchen door was broken in and footsteps were heard of persons entering the kitchen before the parents could get out of their bedroom. And then several gunshots were heard, causing the parents to scramble from the bed to the floor with their younger son, Sazi. Their bedroom door was shortly thereafter opened and the husband made to lie prone, face down, in the passage outside of the bedroom 1 and lounge. Men were shortly thronging the house. If you turn over to page 92. The interval between the storming of the door and the gunshots were approximately several seconds from the parents' recall. The parents were both fast asleep at this time, and they related that they think in retrospect that Kwazi had either fallen asleep upon the couch in the lounge that night, but at that moment, when abruptly awoken, were under the impression that Kwazi was asleep in his own room. What I want to put to you about this is a factual narrative conveyed to these experts by the parents, but it is perfectly compatible with the expert opinion of Captain Mangen, who says, upon his examination of the scene, this child was shot while asleep.
I agree with you.
Yes. If you then skip E5 to E7, you go to E18. They have now killed the child. Mr. Padayache has killed the child. Then this is what happens. Mrs. Ndlovu did not know or suspect
Are
that
you reading that?
E1.8.
E1.8.
Yes, Madam Chair. Mrs. Ndlovu did
Where
not.
does it say Mr. Padayachi has killed the child? Are you putting it to the witness?
Yes, when they talk about the shooting, it has already happened by this time, because
Yes.
the shooting is at E1.3. Yes, so the child has now been killed, but this is now the aftermath. E1.8, Mrs. Ndlovu did not know or suspect Kwazi was injured and repeatedly requested for her to remove Kwazi from the room or the house, and so that she could remove both sons to their grandmother's care after the incident of the entry of the police. She was repeatedly told that they were still questioning Kwazi. It was only when her husband returned from H2 section with the police that he told her, what he now suspected and was the reason for a crime scene police cordon tape applied around the scene. Mrs. Ndlovu then stormed through the tape cordon and peered into the lounge window, where she saw her son with an injury to the arm and a firearm at his side. She shortly thereafter entered with the paramedics who arrived and also managed to obtain some pictures on her cell phone. The reason why this is important is that Captain Mangena says his examination is that the crime scene must have been tampered with because there is the inexplicability of the firearm. When Mrs. Ndlovu was denied entry to the room where the child was killed, that too is compatible with an attempt to tamper with the crime scene. Otherwise, why would you stop a parent from entering the room where the child has been killed?
That's possible, I agree.
Now, if we then look at what they say, are their conclusions at page 102. Sorry, not 102. I think let's start at 101. We're going to still go to 102. 101. At E8.3. They say the 4 rifle cartridge cases indicate that at least 4 rifle shots were fired. If so, then 1 shot of these did not impact on the deceased. Now that again is consistent with Captain Mangena's conclusion that 1 of the bullets shot through the sofa and 3 landed on the body of the child, correct?
That is correct.
Yes. Where this additional shot had impacted is not apparent in the photographs. The padded couch will not easily reveal such perforations in a photograph, but its actual examination showed a single direct impact of its 2 perforations. That again is, Captain Mangena came to the same conclusion. Then they say it is evident from the photographs that the body position had been altered at least slightly after death. Remember that this is also the same conclusion of Captain Mangena, that they tampered with the body after the death. Correct?
Yes, that's correct.
Yes. However, the location of the wounds on the body, the lack of other blood stains anywhere else in the visible surroundings other than that noted in C above, and the location of the cartridge cases on the floor all suggest that the deceased was lying in that general supine position upon the couch, as shown on the photographs when he was shot. Again, Captain Mangena also came to the same conclusion that this child was shot while in a sleeping position. Correct?
That is correct.
Yes. Then in paragraph 3, considering the incapacitating effect of the gunshots, it would also be most likely that the deceased did not also make any significant voluntary movement after the injuries. Such gunshots are very destructive and must be considered immediately incapacitating for most of these cases, not allowing for the victim to be capable of any reactive or retaliative actions. The death would also have occurred very shortly, within a few seconds, if not immediately, after the gunshots, when considering the effect of such high-velocity gunshot to the head with a lodged bullet. Now, you remember that I said to you, what the experts say is that this 5.56 millimeter bullets shot through an R4 and an R5 are weapons of killing. And that is perfectly consistent with the conclusion reached by the expert, that these are very destructive and immediately incapacitating. Do you accept that?
I don't doubt that.
And then paragraph 4, the temporal sequence of body shots, which shot was sustained first, second, and third, cannot be determined from the photographs or autopsy findings. So there is no finding there. Then paragraph 5 is also a very concerning paragraph. It says, The general appearance of the posture of the deceased is that of relaxation in the supine position. This is not reconcilable with the usual posture adopted in firing a weapon. You remember that Warrant Officer Padayache claimed in his statement that this young boy had a gun and was trying to shoot at him, and he shot him 4 times in self-defense. But the experts say that narrative is inconsistent with the posture of the deceased, which was of a relaxation in a supine position, not reconcilable with the posture adopted in firing a weapon. Do you accept
I see
that?
that. Yes.
Yes. Number 6, the absence of any handgun cartridges at the scene suggests that the handgun was not fired. So even though, if you go to page 385, yes. Even though if you go to page 385, there is a gun, volume 2, Madam Chair, thank you. So even though if you go to page 385, you see under the left elbow of this young man, there is a weapon. The experts say he was supine when he was shot. No cartridges could be found, meaning that that handgun was not fired.
That's correct.
Yes. Then paragraph 7, which is also compatible with Captain Mangena. The position of the handgun on the couch is also not easily reconcilable with the final rest of the weapon if it had been held in the right hand at the time of sustaining a high-velocity destructive shot through that right forearm. If the weapon was held in the left hand, it would have landed on the body of the deceased or close to his upper thigh region. The possibility that this was not the actual position of the weapon, as depicted in the LCRC photographs at death, must be considered. They are not as forthright as Captain Mangena, but the general thrust is the same, that it is improbable, let me not say impossible, for this weapon to have been held by this young man at the time of the shooting. Do you have any comment?
No, I agree with that.
Yes. Now, then I wanted to then go to 102, and then if you turn to 103, there is 2 more conclusions there.
Just finished 102 at 7.
It's 102 at 7. I want to turn to 103 at 6.
At 6.
Yes.
Yes.
Yes. There are, sorry, I said 3 conclusions that are crucial to put to you. The one is at 6, where they say the evidence suggests that the deceased was in a reclining position at the time of the injuries. So they've used supine, they're now using reclining, but it all comes to the same thing. The general position and posture of the deceased suggests that he may not have had advance warning of the shots. The appearance of the blood staining indicates that the deceased was lying as depicted in the photographs at the time of the shooting, that he was likely in a relaxed position upon the couch when he sustained the injuries. So that's consistent with what we've read so far, correct?
That is correct.
Yes. Then, if you look at paragraph 8, assuming that the deceased was right-handed, the observation above may also not be reconcilable with the deceased having held a gun in his right hand at the time of sustaining the gunshots. And the reason why they mention this is because they are reading these statements of Warrant Officer Padayache that say this young man was carrying a gun on his right hand. And they're saying this is just irreconcilable with the facts, correct?
I agree.
Then paragraph 9, the handgun seen in photographs does not appear to be cocked, and no spent handgun cartridges were found, should be spent handgun cartridges were found at the scene. So they make a different point here, that not only was the gun not shot, it was not even cocked. Correct?
That is correct.
Yes. And then the handgun was not fired, so we've already dealt with that in the previous section. But they make a further opinion. It is also our opinion that the handgun positioning, as seen in the photographs, requires investigation, as there is a possibility that this could have been an altered scene. Now, this comes into that whole thing that this gun was most probably put there after the shooting, which is the conclusion of Captain Mangena. Do you see that?
Yes, I do.
Yes. Now, thank you. Now, the reason I've had to go through this is because in your report, or your response rather, to the family, you give a thoroughly misleading account of what the expert says, and you don't even submit to them the expert report. Was that because of what the DPP told you?
It's not misleading on my part. It was what I assume I would have received from the DPP. The way the process works in the office is that when there are these issues, it goes through the division called NPS in my office, where the DPPs report to the Deputy National. They would send reports to the NPS. They look at the reports, they draft a response for me, and then the file comes through to me, and I then look at the file and decide whether the draft needs any changes, etc., and then I send it. But that's the process. So in this case, I can only say that this was because of what the DPP sent to me, but I have to add that it is, I agree, very, very concerning that these witnesses were not called, given what we have just read now in these reports.
No, you see, Advocate Patoy, the issue of the witnesses not being called is one issue. What I am probing now is you, in a letter that you've signed, giving a misleading picture of the evidence of the ballistics.
It was what I would have written on the basis of what the DPP provided. And you may rest assured that this is something I have to follow up on.
This is the problem I have, is that you've repeatedly in the course of this testimony singled out this case as the one example that was prosecuted leading to an acquittal, which is why we've had to go through a thorough examination of what happened. You did not even ensure that this report we've been dealing with is part of the docket.
I was not even aware of it, and I didn't disclose the docket. So I was not involved in that process at all. So to attribute that to me is, I think, really unfair.
No, but you refer to their report in your letter. I'm not attributing it to you. You are attributing it to yourself.
Can you refer me? Sorry, which page is that again?
Page
I'm flipping
160
between
of
pages.
file 3.
File 160. Yes.
At the third paragraph, where you are talking about the consultation of Advocate Sankar with Mr. Stale and Dr. Naidu.
I see that.
Yes. Now, this is why we've had to find their report in order to understand what did they conclude in their report, to see whether the conclusions you made were fair conclusions. or unfair conclusions. We came to the conclusions that not only were they unfair, they were also misleading.
These conclusions were, I can only assume, I don't have the report now, but that is the way the process works, is the DPP would have provided a report, and this would have been drafted on the basis of that report. But I have to emphasize, on the basis of what has emerged today, I will have to look into this matter further. There
Now-
seems to be something that was not right.
Yes. Now, this is part and parcel of the problem. You know, you've brought in a senior Director of Public Prosecutions of extensive experience who went through these dockets, came to the conclusion that at least in the KwaZulu case, there should have been a prosecution. Having gone through these dockets, and you've said there was no evidence, there was no evidence, there was no evidence. You've singled this one out. You've said they were withdrawn. We tried to prosecute, there was an acquittal. We go through this on a cursory basis. The three most important witnesses, Mr. Stale, Dr. Naidu, Captain Mangena, are not called. The parents come to you and they say evidence has been suppressed. No independent investigation. I think that on that summary, it is fair to conclude that you have been complicit in denying the parents of KwaZulu justice.
If I may comment on that,
Yes.
that is certainly not a conclusion that is justified in these circumstances. As I explained, firstly, to deal with the issue of no evidence that I have mentioned, I thought I made it quite clear that it was no evidence relating to the racketeering charges. And that is why all of the dockets were sent to the DPP to look into each one of them, to see if there was evidence to charge in respect of each of the dockets. This particular case, I was not aware of these reports of the ballistics experts. Having been made aware of them today, I will certainly take steps to look into this matter, because it's on the basis of what has been read out now, it appears that these witnesses should have been called for the trial, at the trial.
No, you see, a problem, Advocate Batoy, it doesn't help for you to talk about racketeering, because this was one of the predicate offenses. So it was part of racketeering.
It does help to talk about racketeering, because racketeering has very specific elements that you need evidence to prove. And the conclusion that they came to is that there was no evidence to support the elements of the racketeering charges. And that is why I again emphasize the dockets were sent back for the DPP to consider each one of them, to decide whether charges should be brought in respect of any charges in those dockets.
No, I think we are not talking about the same thing. I am simply putting to you that this is one of the predicate offenses in the racketeering charge. Is that correct or not?
This would have been one of the predicate
Yes.
offenses in the racketeering charges, but you need two predicate offenses to satisfy that element for racketeering.
No, don't worry. We will go through all of them. But I'm simply putting to you that this would have been necessary for the racketeering charge because it is one of the predicate offenses.
It would have been one of the predicate offenses, that's correct.
Yes. Now, you now say, well, I'm going to investigate this matter further, and I will be taking action because I can see that witnesses that should have been called were not called. The problem with all of that, it seems to me to be regret after the event that you failed to do your job diligently at the time.
That is not correct. I relied on a DPP's report. I was not aware of these documents and reports. Now that I am aware of it, I'm not going to ignore it.
Yes. Madam Chair, I'm going to move to another topic. As I see that it's 10 to 11. It might be a convenient time.
If I may, this report of the DPP, Madam Harrison, I suppose,
That is correct, Chairperson.
can it still be found?
It should be on the file, Chairperson,
Which file?
on the file in the office. Sorry, in the office file.
Is it possible that it can be made available to us?
Yes, Chairperson, can be.
When?
On Monday.
On Monday, the 15th, please assist the NPA team, please assist in that document being filed of record so that all the parties, including ourselves, the panel, should have a look at it. We should have it by Monday. Remember, we are online, so the document can be made available to us even tomorrow. Thank you.
May I? Advocate Batohi, it is on record. It is on record that you have not read the dockets relating to the racketeering charges.
That is correct, Chairperson.
And what I would like to know is your approach towards dockets in particular. Is it your approach that you have insulated yourself from reading dockets as a general approach? Or what is the position?
Chairperson, as a general approach, I do not read the dockets. I get reports and evidence is summarized depending on the circumstances that led to the matter being brought to my attention. If there's something in it that sometimes I do statements, I ask for statements, but as a general rule, I rely on reports from the DPPs.
So it will be safe to say you have insulated yourself from reading the case documents.
I wouldn't say I've insulated myself. It's just that it's very difficult for a DPP, for a national director to be reading dockets. So it's reasonable to expect that you would rely on reports from the prosecutors in the matter or the DPP.
Thank you.
Thank you, Council Advocate Batoyi. We'll take a tea adjournment until 11:15. We adjourn. Good afternoon. I see Junior. Good day. You have moved positions. Have you been adopted? It is okay.
I've actually asked Advocate Nguetowi to inform the panel as to the reason why he's here. He's a welcome visitor.
It's okay. You can adopt him. I'll approve the adoption. Remember, we are a family here. Thank you. Advocate Batoyi, you are still under oath. Thank you.
Noted, Chair.
You may proceed, Counsel.
Thank you, Madam Chair. Advocate Batoy, during the adjournment, I was requested to put two more propositions to you on the matter of the young man KwaZindlovu. The first one is whether you admit that KwaZindlovu was not a wanted suspect.
All I can say is the evidence certainly seems to indicate that he was not a wanted suspect.
Yes. The second one is that the evidence is also clear that this was simply a case of mistaken identity. They got to the wrong house and they shot the wrong person.
It seems to appear from the evidence that that is possible.
Thank you. Could we move on then to the next topic? We spoke at length, well, you spoke at length about, I think his title is Colonel Ari Danikas, who was a police reservist. You remember that?
We spoke about his statement being unsigned.
Yes, I know we did, but I want to confirm if that is consistent with your recollection.
Yes, we did. I did speak about him.
Now, he was assigned to the Ketumano unit, working directly under Major General Boysen between the years 2000 until he fled the country in 2008, correct?
I think that is correct. I don't have his statement in front of me, but it seems to resonate.
Yes. Well, we can go through it. Now, according to him, he left this country because he was terrified that he would be killed by the members of the Ketumano team, correct?
I can't recall that.
Yes, all right. But you can't say yes or no.
I can't say yes or no.
Yes, thank you very much. Could I ask you to go to file 2 at page 515?
Page.
515, file 2, Madam Chair. Now, that is an email written for your personal attention, addressed to Ms. B. Makeke by Colonel Danikas, correct?
That is correct.
Who is Ms. Makeke?
She is the head of communications in the NPA.
Yes. Did she bring this letter to your attention?
I don't recall seeing this letter.
But if a letter is addressed for your attention,
I see that.
would there be any reason why the head of communications?
Just wait for counsel to finish. You just interrupted and said, I see that when he is talking. And wait for him to ask you a question and answer.
Noted, Chairperson.
Just do that, please.
I thought he was finished. I know, I take note.
Advocate Batoi, please.
Sure, I will do that.
Thank you. If a letter is addressed for your attention, is there any reason why Ms. Makeke wouldn't take it to you?
It should come to me.
So we can assume that it did go to you.
No, we can't assume that.
Well, that's why I've just asked you. A letter is addressed on the 7th of August 2019 to Ms. Makeke for your attention. Is there any reason why she would not bring it to your attention? You said it should come to you.
That's right.
So what are you saying now when I say to you, we can assume that it did come to your attention?
No, we need to check why it did not, because I certainly can't recall having received this email.
Well, is Ms. Makeke still employed by the NPA?
Yes,
So it should not be difficult to ask her to check her emails, whether she forwarded this to you or not.
that's correct.
Yes. I'm more interested in the content of this email. This is brought to your office for your attention on the 7th of August, 2019. Firstly, he says, my name is Aris Danikas. I was approached back in 2011 by the South African authorities to assist them with an ongoing criminal investigation of a police unit called K2 as well as General Boysen. I was visited 3 times by members of the police and the NPA between 2012 and 2016 in Greece. By then, I was forced to return to Europe after living in South Africa for nearly 20 years. The reason for my sudden and secret departure from South Africa is disclosed in my official statement issued via an MLA request in 2017. That is what he brought to your attention in the first place, correct?
That's what in the email.
Yes. At this point, I would like to strongly protest of the matter I was handled as a state witness for the prosecution. Not only was my safety compromised repeatedly by not receiving any kind of protection as promised by many officials, such as Advocate Dawood Mayema, as well as General Mabula, but furthermore, my human rights were violated when the NPA submitted my unauthorized draft notes as a commission statement to the court in support of their charges of racketeering against the accused. Now, you've repeatedly mentioned that unsigned statement, but do you see that he actually owns them as his draft notes?
I see that.
Yes. Then, in the next paragraph, he says, later on, the NPA did receive a statement by me, only to use it as an excuse to justify previous reinstated charges of racketeering. Although there was hardly any feedback of the progress of the case to me, I had to eventually find out via the media that the case was dropped recently. Remember that yesterday I asked you whether there was any attempt to contact some of the witnesses that were crucial on your part when you dropped the case. You said that you didn't, correct?
That is correct.
And here is a witness that is expressly complaining to your office, at least, about not being consulted when the case was dropped, correct?
That is correct.
Yes. Then you say, in the meantime, then he says, sorry, in the meantime, I received last week a hate letter from Boysen himself with fabricated and unproven allegations against my character attached. Is that correct? That's what he says?
That's what he says, yes.
Now let's just look at those attachments. Go to page 518. So according to Colonel Danikas, Mr. Johan Boysen wrote to him in a WhatsApp on the 26th of July, 2019. And that is a copy of a WhatsApp sent to Colonel Danikas. You would not know about that, would you?
I haven't seen this. It's the first time I'm seeing any of this.
Well, these were submitted as part of our evidence last week already.
I know. I haven't had time to go through all of your
Yes.
information.
But in addition to that, it was attached in 2019 already to your office.
I said that was so.
Yes. Now, he says, General Boyson says to Mr. Danikas, and at this point, we must remember, Major General Boyson is an accused in a murder case. He's also an accused in a poker infringement. He is texting a witness and says the following: "Hi, Malaka Draft Dodger. You are making a fool of yourself. Why don't you come and testify in South Africa? You are a coward." Let's just stop there. Now, Major General Boyson knows full well why Mr. Danikas fled the country. It is because he was scared of a possibility of murder by the K2 minor unit. Is that correct?
I have no idea. You should ask that of Major General Boyson.
Well, I am putting it to you. It was public and common knowledge. It
I
was
have
even
no
part
idea.
of the statement. You don't know?
I don't know about that.
Yes. Now, what I'm interested in is the statement, why don't you come and testify in South Africa? You are a coward. That strikes me as a direct intimidation of a witness, which would be a crime. Would you accept that?
I don't know.
You don't know.
No, I don't know. I really don't know whether it would amount to intimidation.
The words, where a witness has fled the country because he is afraid of you, you say to them, come and testify, you are a coward. Don't you regard that to be intimidation?
I'm not sure. We'll have to look at the whole context before we decide it is.
So you are not
I
prepared
beg
to...
your pardon. What context do you have in mind?
Chairperson, if there must be, the matter must be investigated and we must get all the evidence before we can make a decision. I can't, on the basis of one statement, say that this is intimidation, Chairperson.
So
You may proceed, Counsel.
So you are not prepared to say an accused person who makes a contact with a witness in their case, knowing full well that that witness has fled the country because they are scared of them. An accused person saying, come to South Africa to testify, you are a coward. You're not prepared to admit that that would amount to intimidation.
I'm not sure. I'll have to look at all the facts, as I said.
Yes, I'm not asking you that question. I'm saying you are not prepared to admit that that would amount to intimidation, yes or no?
I can't admit that without all the facts.
And then when he says you are making a fool of yourself, are you prepared to admit that he is insulting the witness?
Yes?
Yes. And when he says you are a coward, what does that tell you?
I think we should ask General Boyson these questions.
I'm asking you as the NDPP head who is responsible for exercising prosecutorial authority on all our behalf in this country. When you say something like this, an accused person makes a contact with a witness.
You should not be contacting a witness. That's correct.
Yes, but I don't understand then why we went through all of this. If you know that this contact is itself illegal, why we've had to go through this?
I wasn't asked whether he should be contacting the witness. I agree, he should not be contacting a witness.
Yes. But not only does he contact the witness, he is threatening them and intimidating them, which is something you're not prepared to admit.
I can't admit that.
Now, there is a second WhatsApp message, which is at page 519. Where Major General Boyson sends another WhatsApp to Mr. Danikas. And he says, you tried your luck with my juvenile daughter when we were in France. And then he says, I told you then.
Sorry, Counsel. Is this not a continuation of that WhatsApp? Because this was
Yes,
26
sorry.
July
No, sorry, Madam Chair.
1936,
Yeah,
and there appears to be,
Yeah.
it could be a
No,
continuation.
it is. It is. Actually, to show that it is a continuation, look at the time on your left at
Yes.
5:18.
Yes.
Thank you for the correction, Madam Chair. So that same message continues at 5:19, and it says, "You tried your luck with my juvenile daughter when we were in France." And then look at the words that come thereafter. "I told you then that I will F you up." Now, are you prepared to accept that if an accused person tells a witness that I will F you up, that would be a case of intimidation?
Yes, I agree.
Yes. Now, if you then go further down, 1, 2, 3, 4, to the statement that starts with, "It is a pity." Can you see that?
I see that.
Now, he again says to the witness, "It is a pity you did a bad job when you cut your wrists when your girlfriend dumped you." Now, cutting your wrists is associated with suicide, correct?
That's correct.
When he says, "It is a pity you did a bad job," what he is telling the witness is that you should have killed yourself.
I agree.
Yes. Now, again, you have a witness. You have a witness being told by an accused that he should have killed himself. That seems to be an extreme case of witness intimidation and witness tampering.
It appears to be so, I agree.
Yes. Now, that is done by the person of very, very high office. He's a major general in the police and held the provincial commander of serious and violent crime in KwaZulu-Natal. He must know that what he is doing is illegal, correct?
He should know that.
Yes. But moreover, it is brought to the attention of the NPA. We see absolutely no action being taken against Major General Boysen for witness tampering, witness intimidation, witness threatening, witness insulting. Correct?
I've not seen this letter, and it's correct. It appears that there was no action taken. I mean, this email.
Yes. Can you explain what would be the motive, if you can speculate, if you don't want to fine? Why would it be in the interest of Major General Boysen to tamper with a witness?
I think you should ask him that.
Yes. Indeed, I am told that you intend calling him, or the NPA intends calling him as a witness.
I don't know. The evidence leader decides on who to call.
Yes, but I thought you repeatedly told us that there were witnesses that were coming, which you did not name. Is he one of them?
I think the evidence leader will confirm whether he is or not. I don't know.
No, to your knowledge, you said you don't know.
I don't know.
Yes.
It's his decision.
Well, did you consult with him before these hearings?
No, I haven't.
Yes.
Do you remember that we were given by the evidence leading team a document signaling the list of names of witnesses they intend to call quite early
Oh,
during the hearing? And Major General Boysen was on that list.
okay. So I assume then he will be called, Chairperson.
I beg your pardon?
I assume then he will be called.
I'm asking you a question. Do you remember, if you do, that we were given a list, a witness list, quite early during this inquiry, where the evidence leading team gave us a list of names of witnesses they said they intended to call, and Major General Boysen was on that list?
I don't recall, Chairperson, if I've seen that, but I do recall some conversation about sharing list of witnesses.
That's better. Thank you.
Just a follow-up. Did you participate in the exercise of assisting the evidence leaders to identify witnesses that will be called?
We had some excuse me. We had some conversations around witnesses that can be considered, but always making it clear, and the evidence leader himself making clear that he will decide who to call.
Is General Boyson one of the witnesses that were proposed to be considered by the evidence leaders?
His name must have come up as one of the potential witnesses, I'm sure.
From the NPA?
Yes.
Thank you.
Yes. Now, Advocate Batoy, we are still on this topic where an accused contacts a witness, which you say is illegal. Not only do they contact the witness, they threaten to F them up. And then they tell them that they should have killed themselves. That witness comes to the NPA, particularly to your office through Ms. Makeke, and reports it. And no steps are taken against Major General Boyson, who is a very senior figure in the police. Now, that conduct on the part of the NPA, is that normal? Is that acceptable?
It's not acceptable that this matter was not brought to my attention or dealt with.
Well, now you have changed your version that this matter was not brought to your attention. Initially, you said you were not sure if it was brought to your attention or not.
Well, when I read the WhatsApp, I don't recall at all seeing something like this. And then I realized it couldn't have been brought to my attention because I've definitely not seen a WhatsApp like this.
Yes.
No, we are in a fact-finding process. And it is open to this inquiry to make sure that all relevant information for this purpose should be gathered and be brought to our attention. Now that you mentioned that Ms. Makeke is still an employee of the NPA, shouldn't she be brought here? Either at the instance of the evidence leading team. If not, it may be at our instance. Would you like to make an investigation as the head of the NPA to ascertain from her about this communication?
Yes, Chairperson, I will do
Before
that.
we even consider whether she should come and testify or not.
I will check with her, Chairperson.
And when do we know that you would have spoken to her?
By Monday.
Yes.
Evidence leader, we should know by Monday. I'm speaking through you, senior counsel. By Monday, we should know about the position of Ms. Makeke and whether this communication happened. If not, you'll consider your position,
Indeed, Madam Chair.
acknowledging your role before us. This is not a criminal case, this is an inquiry. And when a matter is brought to our attention that seems to be necessary to consider, you will consider your position. And if you don't, it may be necessary for us to employ you to call that witness.
It's taken,
We'll leave
Madam
it
Chair.
there with the view that we will know on Monday what the position is, because Advocate Batoy makes it clear that she does not remember if this email communication that was directed to her was actually brought to her attention. You may proceed, Counsel.
Thank you, Madam Chair. Advocate Batoy, can you go to page 520? Now, that is a response from the acting Deputy National Director of Public Prosecutions. It looks like it's Advocate S. Mzinyati, although it has been PP signed on his behalf. Who is Advocate S. Mzinyati?
He would have been acting Deputy National Director at the time.
Does he work in your office?
Yes, he does. He's a Deputy National Director in charge of the National Prosecution Service. Well, he was acting at the time, and he is acting at the moment as well.
Please, Counsel, take me back to where you were. I
Page
lost
520 of the same bundle,
520.
volume 2.
Thank you.
Yes. So, do you know how this communication from Mr. Danikas, which was not addressed to him, but was addressed to you, ended up on his desk?
It seems like it was forwarded to him. He is a Deputy National Director, and he is the head of the National Prosecution Service. So this would have been one of the matters. The NPS deals with representations, that is their portfolio. So it looks like he responded to that letter, that email.
Yes. It's clear that it came to his attention,
That's correct.
but the question is whether it came to his attention from you or from someone else.
I didn't send it to him.
Yes, and you did not ask him to attend to it because it's correspondence to the NDPP.
He has delegated authority to deal with matters, representations.
Yes.
The Deputy National Director of NPS has delegated authority to deal with representations.
Yes. Well, representations is one thing. A report of a crime, witness tampering, is not representations. Now, the witness was reporting a crime to you, witness tampering, which we've gone through. That would not be representations. That is why I ask you whether it is not you who asked Advocate Mzinyati to address the crime that was being reported to you.
I really can't recall sending this to him. I can't recall having received this email or sending it to him.
Now, when you actually look at the content of what he says he acknowledges the receipt of the communication. It says dated 8 August, but when you actually look at 515, it's 7th of August. But maybe very little turns on that. But then he says it has been forwarded to the Acting Director of Public Prosecutions of KwaZulu-Natal for her further attention. Was the Acting Director also at that stage Miss Elaine Harrison?
Yes, that's correct.
Yes. Can you explain what the logic of sending a reported crime to the Acting Director of Public Prosecutions could possibly be?
I can only imagine that, given that this matter was a KZN matter, he forwarded it to the DPP to deal with it as appropriate in KZN.
Well, we know for a fact that in the case of Major General Boysen, it was not a KZN matter, it was an NDPP matter because of the provisions of Section 2 of POCA. So can you then answer my question? Why would the NDPP's office send a crime that has been reported to it in relation to a matter within its exclusive jurisdiction to the DPP's office of KZN?
I can only imagine and repeat what I said, and that is why Advocate Mzinyati saw fit to send it to the DPP KZN.
Yes, but
given that it was a KZN matter.
we know, Advocate Batoi, that racketeering is not a KZN matter. It is an NDPP matter. And that is why this answer you've given simply misses the point. There is a witness in a racketeering case who has been intimidated and threatened by an accused. He reports that crime to you via Ms. Makeke. No one does anything, it's forwarded to KZN. Why is that so?
I can only give you the answer that I did. That was what Advocate Mzinyati thought ought to be done in the circumstances.
Then the letter goes further. It says, you are requested to direct any further correspondence regarding this matter to the aforesaid acting director. The contact persons at the said office are Ms. Ashika Sechuran and Notando Mbisi, and their contact details are as follows. It seems that your office is washing its hands over this reported crime. Correct?
I think Advocate Mzinyati did what he thought was appropriate and forwarded to the DPP for appropriate action.
Well, I'm putting the question again, that your office washed its hands of the crime that was reported by a witness allegedly committed by Major General Boyson in relation to a matter that was exclusively within the NDPP's office.
I can't agree with that because Advocate Mzinyati forwarded it to the DPP KZN for further action.
Yes, but the office, your office itself, the NDPP's office, took no action in the matter. Hence, my proposition that they washed their hands over a matter where they had exclusive jurisdiction.
That's not correct. The action that he took was to forward it to the KZN DPP.
And you endorse that action.
Well, it should have been brought to my attention given the high-profile nature of this matter.
You're not answering. You endorse the action of not dealing with the matter at the NDPP level.
As I said, given the high-profile nature of this matter, it should have been brought to my attention, but Advocate Mzinyati thought it best to forward it to the DPP KZN.
So you don't endorse that action.
I endorse it to the extent that he thought it was appropriate.
Yes, but that is what I'm putting to you. Was it appropriate or not?
Well, I've answered that. I said he ought to have brought it to my attention as well.
So it was inappropriate not to bring it to the attention of the NDPP's office.
Perhaps an oversight on his part.
Sorry?
Perhaps an oversight on his part.
This is what I don't understand. You were talking yesterday about justice for the victims. Here is a witness who says, I am reporting to you, I'm a whistleblower. I'm reporting to you that the person I am blowing the whistle against is intimidating me. There is no response to that at all.
Justice for victims is extremely important and one of our strategic initiatives in the NPA. It takes a high priority in terms of our work. Victims are our customers that we serve. In this case, as I said, it appears to have been, given the high-profile nature of this matter, Advocate Mzinyati ought to have forwarded this to me as well as send it to the KZN DPP. Why he didn't, I'm not sure, but he, as I said, he thought this was appropriate action to send it to the DPP in KZN to deal with the matter in the province.
Then the province itself responds to Mr. Danikas at page 521.
The province.
The Director of Public Prosecutions in KwaZulu-Natal. Apologize. And this is what they say. The office of the DPP KZN is not conducting any investigation into the K2 minor unit, correct?
Yes, I see that.
This office is only reviewing individual dockets to determine whether any person is responsible for the death of the deceased in each docket. If you have any evidence of crimes committed, you are advised to liaise with the South African Police Service, who will no doubt investigate the same. There are several issues that arise here. The first one is that the crime that was reported against Major General Boysen has again not been responded to here. Correct?
What the office is saying is that he should report it to the police station, who will investigate the matter.
I'm not understanding that. This is a witness who has consulted extensively with the members of the NPA. It is in the middle of, well, it's already been withdrawn, but he is protesting against the withdrawal. And he says to you as the NPA, I'm being intimidated, here is the evidence. The NPA says goes to a police station. Is that how the NPA reacts to cases of witness intimidation?
Well, it depends on the circumstances. And I mean, the first step is to report the matter to the police so that they investigate it, and then a docket's open and that, we can make a decision in the matter. This was a high-profile matter, no doubt, and could have been dealt with differently in the circumstances.
So the conduct of the DPP in KwaZulu-Natal in also washing their hands of the matter by saying that a witness intimidated like this must go to the police station, was that appropriate or not?
I think it is in instances where there's a complaint of any crime. The first step is to go to the police station, as I said. So I can't say it's inappropriate. But as I said, given the high-profile nature of this matter, perhaps it could have been dealt with differently.
Yes. Now, as matters stand, that issue of the conduct of Major General Boysen in intimidating a witness, threatening to F them up, has never been inquired into by the NPA. Correct?
That's correct.
Yes. Now, let's go back then to some additional points that are made by Colonel Danikas. If you go back to page 515. I'm told his actual title was Inspector Danikas. Now, in the last paragraph of page 515, Inspector Danikas says, I would like to point out that I have witnessed specific crimes being committed by members of the Cato Minor Unit and General Boysen himself, dated up to 2008. I have provided a detailed statement and supporting evidence of such crimes committed by the accused. Now, this is not a case anymore of a witness consulting with the police. He is telling you directly, at least according to him, because he's writing to you, that I am here, I'm a witness, I've seen Major General Boysen committing crimes. I've also got supporting evidence. And that is brought at least to the attention of Advocate Mzinyati. And that, again, is not addressed. Do you have any comment?
I don't have any comment, but clearly he's referring to a witness statement that he had made previously with regard to the racketeering matter.
Yes. Yes, but there is something more, Advocate Batoi. He is saying, in case there were any doubts, here I am. I'm a witness, I'm available, I would assist the NPA. In that context, no action is taken because we know for sure that this did come to the attention of Advocate Mzinyati.
It's difficult for me to comment on this because this was in the context of the racketeering matter,
Yes.
and he had not signed his statement in that matter. And I'm not sure why, the matter was dealt with in this way, but I really can't comment on this
Well,
beyond that.
yes. Well, he is telling you that he has provided a detailed statement.
That's correct.
And we know that to be correct because if you go to page 497 to 514, is a statement written in Greek and with a stamp of the 12th of October 2018, the same bundle, 497 to
Is that-
514.
497.
Yes, 497 to 514. And then the official English translation of that statement is at 480 right up to 496. All of them with stamps and sworn by official translators. There they are. And we got this from Inspector Danikas himself, who was also shocked at listening to your evidence.
Beg your pardon. Will this 482 official translation be the same or similar to what we find at 454?
Yes, there are, Madam Chair, there are, yes, so that was the first one. The substance of it is the same. In other words, the narration of the events, but it's not word to word.
Yeah.
Yes.
Thank you.
Yes. In fact, there are three, now that you're on that question. So there's 454 up until 457. And then there is another slightly improved version, 458 up until 472. And then the signed version, the Greek version that is signed is 497 to 514. The sworn translation is 480 to 496. I mean, and that Greek version is dated 12 October 2018. And the sworn English translation, also same date, 12 October 2018. So the point I'm putting to you, Advocate Batoi, by that time, 2019, you could be under no illusion. There was a signed statement from Inspector Danikas.
I haven't seen this statement. I
Yes.
know there was a Greek statement that was signed. I'm aware of that. But I have not seen, this is the first time I'm seeing a translation that's dated 12 October 2018.
Well, I understood this to be part and parcel of the file. I mean, part of the problem, of course, is that you never really read anything.
That's not a problem. There was a team that was put together to look at the files in detail.
Well, I mean, it enables you, every time a question is put to you, to simply say you're saying it for the first time.
This is not even referred to in the, my recollection, I need to check, is that it's not referred to in the report either of de Kock.
That is actually a lie. It is referred to in the report of the court. What they claim incorrectly is that Mr. Danika's signature was superimposed. But the English version is referred to in the TICOC report, which actually places a further question as to whether you even read the TICOC report, if you say this statement is not referred to there.
I did read it, and I am also aware that there was evidence of Mr. Danika's statement being superimposed on one of the documents. So whether it's this document that we have before us that is being referred to in the statement, or it's another, whether it's another translation, this is an official translation,
Yes.
and whether it's this one or whether there's another translation that they're referring to, I think that needs to be clarified.
Now, Advocate Batoy, please. You just gave evidence that the challenge you have is that the English official translation is not referred to in the TICOC report. I showed you, well, I told you that that is false. It is referred to in that report. You are now changing and coming with a different version.
May I comment on that? I'm not coming to a different version. I'm not changing at all, because the English official version, this one that we have now at 480, I am not sure that they are referring to this. My recollection is that there's mention of a statement, a translation that is not the official translation. And there was evidence of his signature, Danika's signature, being superimposed onto one of the translations. It cannot be this official one because it appears to be official, but there is evidence that that was done with a translation. And my recollection is that is what is being referred to in the TICOC report. That is my recollection.
All right, let's do this. Maybe it will be simpler because it's very
Just
difficult.
look at the report, it will be helpful.
To keep up. Go to SB 3-172.
SB3, that's my affidavit. Is it this one? It's my affidavit, it says affidavit. No, not the legal opinion. This is the legal opinion. It says affidavit on the side. Oh, it's here. Yeah, sorry. This is legal opinion.
SB,
SB3, the relevant page is 172.
172.
Yes. So if you look at SB3 172 at paragraph 118, this is what is stated in that paragraph. Danika's statement in Greek was only signed on 26 October 2016, months after the NDPP signed the authorization on 13 February 2016. But this is the crucial part. The English translation was made available to the prosecution on 12 October 2018. If you then go back to volume 2, you look at page 496. At the bottom of that page of the English official translation, you see the date 20 October 2018. File 2, yes, 496. And there is a stamp at the bottom, 12 October 2018, which resonates directly with the recollection of the authors of the de Kock report. Advocate Batoy, I am not going to press this anymore. I think we've explored what we could on the statement, unless you have any point you want to add.
Well, I'm just not clear because as you see, in 119, it is, there is evidence of, a signature being superimposed on an English version.
Yes?
So again, I can't say anything more. I am confused about this. I need to look into it so that I can understand better what exactly happened here.
Yes, I thought that we were leaving it on the basis that you are confused about it. That's why I said I'm leaving this topic, unless you want to comment. And
No, I'll have to look into this.
yes. All right. Can we then?
But what does that mean? Does it mean that this aspect and many others that you said you want to look at them need to be revisited?
Chairperson, it might mean that I need to look into this and understand what exactly was before the panel when they considered this matter.
Would you like us to pause for 5 minutes so that you can look at that?
No, Chairperson, I think I can deal with it once we adjourn and then we can deal with it on Monday in the interest of time.
How long would you require to look at this aspect? We need such a long time?
Yes, Chairperson, I need to check the report. I need to speak to the panel, Advocate Riley, who's in Cape Town, and just get an understanding of what exactly was they had before them at the time. It might take more than 5 minutes.
And remember, this is not the only instance where you testified that you need to look at things. You might remember, if you don't, your team or the evidence leading team will assist you with regard to those instances that we have been noting here, where you testified, you need to look at the evidence, the records, the documents. They will then have to reflect on their notes or even on the transcription, because we get a transcript every morning. That transcript will be available certainly by Monday morning. But before that, the team, Advocate Mutlamunyane and Advocate Skosana, will have to facilitate that.
Madam Chair.
And, I beg your pardon, and assist us. Because a lot of evidence is left hanging, where Advocate Batoy says, I would like to look at that. I would like to re-look at that. And we cannot proceed without affording her an opportunity to do exactly that. So please make a note. We have made note of those aspects, but it is your role as well to assist us as we search for the correct facts. That should assist you, Advocate Batoy. We will also defer this aspect, and the evidence leading team will remind you of those instances where you'd like to reflect.
Noted, Chairperson.
Thank you.
Thank you, Madam Chair. Look, the only issue, Advocate Batoy, we ended up getting sidetracked, was to simply say that your statement
Madam Chair, sorry, I'm sorry to interrupt. I just wanted, and it looks like Mutlamunyane maybe did not understand. I just wanted to clear up when we
I thought you'll say Advocate Nkabinde.
oh,
Yes.
Mutlamunyane S yes. So sorry, Madam Chair. I just wanted, we are more than willing to assist in the respect that the Madam Chair has indicated. I just wanted to clear up the issue of us discussing with Advocate Batoy while she is under cross-examination. We might experience difficulties with that because it's with regard to issues that she is being cross-examined about. So just that to seek clarity in that regard.
Any objection, Advocate Chauke?
Madam Chair, no, we will not accept that Advocate Batoy should consult on these matters at all. I know that she says she wants to consult Mr. Riley. We again will not accept that. She can only do it with our consent. I thought what she wanted was to read up on her notes, which would be acceptable, but we will not accept that she's entitled to consult with people during the cross-examination. I'm sorry.
Yes, Advocate Skosana, I thought my statement was very clear. A follow-up on Advocate Batoy's answer, not one, not twice, where she said she needs to look into the matters. And I was saying to her, it seems to me that there are many aspects that are left hanging. And I asked her whether she would like us to revert back to those issues. And she said she will need time. What I requested you to do is to find those aspects of her testimony where she kept on saying, I would like to look into this, so that she can actually look into those aspects. I did not think that we are talking about you consulting with anybody. All of you are taking notes as we do. You should be in a position, SC, to reflect on that evidence. And please remember, all of you have a duty to assist this panel, to bring to this panel's attention all matters, either for or against. It is your responsibility as evidence leaders. So I implore you, with due respect, to assist and look into those aspects of her testimony where she said she would like time to reflect so that she can properly reflect on those matters. You are a team of 3, excluding your adopted child next to you, to go through the transcript and assist Advocate Batoy and us. We do have notes, but I will not page back and look at all those instances. I suppose that is clear.
Thank you, Madam Chair. I think I understand, and I have taken note of some of those, maybe not all of them, but I have noted the instances where she says she'd like to look at the matter and so on. The only difficulty is that how do we tell her, like the Madam Chair has said, if we say this aspect on page so and so, this is the page number, or this is what you can look at. How do we actually relate that to her when there's an objection?
Kosana, you are complicating a very simple matter. If you pull out those instances, you can even remember it is when you are asked this question and then convey that to her through Advocate Halley or Junior, if you cannot talk to her. But what is important, or even the lady next to her, because we seek to assist. And once you have identified those aspects according to your notes, SC, you can even bring it to the attention of the junior counsel behind you to communicate those pages or those aspects, because the idea is to assist the witness to capture those instances so that she can reflect upon them and answer on Monday. I don't want us to leave things hanging here, and then when you go to the transcript to write the report, we find that we have failed in our duty to afford her an opportunity to address those matters.
But we'll do our best, Madam Chair.
Sister would like to make a suggestion.
Yeah, maybe, thank you, Chair. Maybe to make things easy, because the question of which items are still outstanding, it's something public. All of us here have been making notes. and to obviate the, the potential of questions around how you communicate. The alternative would be to draw the list, the document that states as to which matters she has to revert to. That reminds her, she also knows, but just as a reminder, in case one or two of those things have slipped up, and send that to the Secretariat so that the Secretariat can send that to everyone, rather than her having contact with you, evidence leaders, or even the NPA.
Well, Senior Counsel, you know exactly what you are supposed to do. I need not guide you on such a basic thing. I think we should proceed.
Thank you, Madam Chair.
Chair, before we proceed, I may have misunderstood the witness, but amongst the things that she said she wanted to do, she said she wants to go and check, reconsider the Cox memorandum and consult with Riley. Did I hear you correctly?
I did say that, yes.
And I think it would be, I don't think that is the correct procedure to follow when you are under cross-examination. So what has already been suggested by my sisters is what you should do. You should get the documents, read through them, and form your own opinion.
Yes, no, that was made clear from Advocate Andrew Chauke as well. So I didn't intend to speak to her after that.
Okay, thank you.
Thank you, Madam Chair. Advocate Batoy, the reason we ended up on this detour is actually straightforward. Paragraph 118 of the DCOG report makes it clear that they did have the official English translation dated the 12th of October, 2018. Is that correct?
Sorry, I thought this was my affidavit, but SB3. Yes, SB3 is the DCOG report. So my apologies for that.
I'm saying paragraph 118 of that report
Yes, sorry, I'm just going
is
to get
clear that the English translation was given to the prosecutors on the 12th of October, 2018.
Yes, was given to the, it doesn't say that they had the English translation. If I could just get back to what paragraph is that? 118. If you bear with me, what page is that?
SB3 172.
172. Yes. It says the English translation was made available to the prosecution on 12th of October 2018.
Yes.
So they say that the team, the prosecution team got it.
Yes.
Whether they had it themselves, I don't know.
No.
And then they go on to say at 119.
Who has asked you about 119?
I'm just trying to get the context right.
All right.
In order to answer your question properly.
Well, my question is simple. Paragraph 118 says that the English translation was made available to the prosecution on 12 October 2018. That's my question.
That is what it says. That's correct.
Yes. Now, your statement earlier that this official translation was not referenced in the DCOG report is a false statement. That's all I'm saying.
It's not a false statement because as I tried to explain, if you look at paragraph 119, according to Maema, he's still in possession of the original statements and none were filed in the docket. So that means it appears that they did not have it, the de Kock team. None of the statements was made available to the defense. He also stated in an email dated 24 April 2019 that the signature of Danikas on the Greek version of his statement was just superimposed on the English version. That's what Maema said. And therefore, they concluded Danikas never signed the English translation, as he pointed out a number of mistakes. So it's not false. I'm still confused about this because we have what appears to be a signed official version dated 12 of October 2018. But we also have at paragraph 119, the panel saying that Maema had indicated that the English translation had not been signed by Danikas. So
I think-
that's my confusion because it appears that it was signed.
No.
The panel, are you referring to Maema's team?
Now, the de Kock panel chairperson,
Dr. Okay, Advocate de Kock's
That's
panel
correct.
Team. Okay,
the 2019 panel.
thank you.
So that is where my confusion comes up when you read 118 and 119. And that is why I thought I'll speak to Advocate Riley, but I won't speak to her now.
Advocate,
I'll have to consider how I can. I don't know that I'll be able to say anything more on this if I don't speak to Advocate Riley. Maybe she needs to explain that.
Advocate Batoy, your confusion is an attempt to evade my question. My question is simple. You stated to this panel that the English translation is not referenced, it's not referred to. That is why we did the exercise of going to paragraph 118, and we found that it's referenced. So that is what I'm saying is false.
As I explained previously, it's not false. I had not, my confusion is that I wasn't sure that they were referring to this particular signed document, because my understanding is that the English translation had not been signed. So that is why when I saw a signed document, you're right, the date is the same. But my understanding from 119 is that there was no signed document, but that his signature had been superimposed on an English version. And that is where my confusion came up. So there's
Even-
nothing false about it.
Even on that confusion, it's clear that the statement is referred to in the report.
The statement, well, you're right, the statement is referred to in the report, but I was confused about it.
Well, we will ask the panel to draw its own conclusions about whether your confusion, alleged confusion, is an invention to avoid an obvious fact that you misled the panel.
It's not a misleading. If you read paragraph 119, I'm trying to explain why I did not think that it was this signed document at 480 that was being referred to in 118.
Yes. If we then return,
Before you move off this one, Advocate Batohi, just for clarity of my mind, you say when you read paragraph 118, or maybe let me preface this by saying you, on several occasions, you mentioned that you relied on de Kock's memorandum.
That's correct.
Now, you say paragraph 118, when you read paragraph 118 and then moved to 119, you became confused. Is the confusion coming up today or back then when you read the de Kock memo?
No, it's only coming up today because I'm seeing this document that's been presented.
Okay, thank you.
yes. Now, if I can then continue with page 515. At the bottom of that page, 515 of file 2. At the bottom of that page where Mr. Danikas says, it appears that they are untouchable, protected via the media or projected via the media as heroes and victims, while I have suffered targeted media attack orchestrated by the accused. None of the fabricated allegations against me have ever been proven, neither any evidence ever being produced. On the contrary, I can provide proof and solid evidence that Boysen has lied on multiple occasions under oath regarding the Cato Minor case and myself. There are repeated criminal patterns established, such as the ones I have witnessed and reported within my statement previously. I have witnessed torture within the Cato Minor office of a suspect. Such reports of torturing suspects by Cato Minor officers have been reported previously by the media as well. I have submitted a video of such incident and such similarities as mentioned below on another case. And then there, he then encloses the torture video. Madam Chair, can we play that video? Because we asked Mr. Danikas for it. He gave it to us.
Yes, thank you. Have you made arrangements?
Yes, that's why we've asked the junior to come here. And what you will see, according to Mr. Danikas, are 4 men surrounding a man. It's a bit graphic, so I beg for forgiveness. But it is the video that he gave to Advocate Batoi's office, so she won't be surprised to see it.
I have indicated I did not get this email. So I'll look at it now.
Just stop there. Yeah, stop there. Yeah, stop there. Now, according to that video, the 4 men surrounding the person that is sitting on the chair were all members of the Cato Minor unit. That will be the testimony of Inspector Danikas that will be called to this inquiry.
Is this the best depiction that you have? Because I don't see 4 men there.
Yes, well, there are 1, 2, 3, 4. They are standing. And then there is a man sitting down who is naked.
Is it possible to minimize it to see the 4 men?
I'm not sure about his
I'm not sure
techno
about-
skills. I know he's got many other skills, but
Is it possible to minimize and just look at the pictures of the 4 men there? I see 2.
Mouse, maybe try to point.
using the mouse. Yes, all right, thank you. Will you do that, please?
Please point at the first man.
Maybe he can give a description.
Yes. So the
Yes.
gentleman that is wearing, I think it's a green shirt, and that appears to be denim jeans, is one of the men from Cato Mano. Then there is another gentleman with a light-colored shirt who is standing behind the suspect, also is from Cato Mano. Then there are 2 men with black shirts that you will see on the left-hand side of the suspect. Those are also from Cato Mano. Now, sitting on the chair is a suspect who has been undressed, and they've put a plastic bag in his head. The plastic bag is blue in color, and the man is naked.
Yes, Council, I see then, but do we know whether they are from Katomena or you're going to deal with
Yes,
that?
the witness who took the
witness.
video is Inspector Danikas.
Yes.
He will testify that those are Cato Mano torture videos that he took himself.
May we please go back to that part of the statement that refers us to this video?
Page 516.
516. Yes, thank you.
And then he says there are repeated criminal patterns established, such as the ones I have witnessed and reported within my statement previously. I have witnessed torture within the Cato Mano office of a suspect. Such reports of torturing suspects by Cato Mano officers have been reported previously by the media as well. I've submitted a video of such incident, and such similarities are mentioned below on another case. And that's the video that is referenced there that he gave us in consultation. And he will confirm that he took that video himself. Let's continue, play it to the end. Yes, thank you. Advocate Batoy, have you ever seen this video before?
No, I hadn't.
Yes, you know, the difficulty with that is that yesterday we looked at the interactions between you and Advocate Epstein SC. Where, if you go back to file 3, yes. So if you go back to page, to file 3, page 257, you will see that is part of that memorandum that Advocate Epstein did for you and gave it to you in preparation for the meeting of the 6th of March. And if you go to page 256 of file 3, sorry, 257.
Yes, let's start. The memorandum is at 257.
The memo starts at 254, Madam Chair. The memo starts at 254,
And the page
257.
257. Yes.
And at paragraph your advocates already told you about the existence of these torture videos. It says Danikas supplemented his statement and handed Mayema additional photographs and video clips on flash disks. Do you see that?
I do see that.
And then when you had the meeting with it's file 3257, Madam Chair.
Yes, thank you.
Paragraph 4.
Yes, thank you.
Yes. Now, if you are at 257, paragraph 4 says Danikas supplemented his statement and handed Mayema additional photographs and video clips on flash disks. So what I'm putting to the witness is that she knew as early as the 6th of March, 2019, that there were video clips which were submitted as evidence in this case. And when you go to the actual meeting of the 6th of March, which starts in the same file at page 335, and specifically at page 338, Mr. Epstein stated there, 1, 2, 3, 4, on line 5.
Sorry, just a moment. Is that in a different file? 338.
No, 338 of file 3.
Oh, just a second. It's okay. Yeah.
And the 5th line where it says, Sean is given presentation. Johan Boysen, item 27, gets Danicus's supplemented statement and looks at what is on the flash drive and then issues. So not only were you told in the memorandum, you were also told verbally in the meeting about the existence of these videos. And then the witness himself tried to bring them to your attention in this letter at page 515. Do you have any explanation?
I will certainly comment on that. Firstly, with regard to what is said in Advocate Epstein's memo, with regard to the existence of certain types of evidence, after this meeting, I had made a decision to get a panel to look into all of the evidence and give me an opinion. So there's nothing untoward about me not seeing those videos, because a panel was looking into all of the evidence and this was part of the evidence. That's the first part of it. And the second part of it, as I indicated, I cannot recall receiving that email with the video links to it. So there's nothing untoward about the fact that I would not have seen this video or that I see it today for the first time.
Yes. What I don't understand is that there have been at least, well, this is probably the fourth attempt, because even if you look at the original unsigned statement of Mr. Danicus, it references these videos. If you go to page 474 of file 2,
That one, 474. Thanks. $470?
4.
Yes.
But the reference to the video clippings is at 474. In the first paragraph, towards the end there, where so if you look at the last line, in 2008, after I left South Africa, I placed clippings of the recordings on YouTube, case number 297/02/04. Right at the end of the first paragraph. So that was the original, the first time this was referred to. I've already gone through the 2 occasions where Mr. Epstein refers to it. But if ever there was doubt, your affidavit at page 63. I don't know where I lost you, Madam.
The relevant page and the paragraph that you referred to.
Oh, it was volume 2, sorry, file 2, page 476.
476.
Yes, the first paragraph, the second last line, which starts with in 2008.
Okay, thank you.
Yes, thank you. Then I had moved from that to say even the witness's own affidavit shows familiarity with the fact of this evidence existing. And I was bringing the witness's attention to page 63 of her affidavit, where she quotes Advocate Jiba.
Where exactly is that?
It's page 63 of your affidavit, and you've quoted paragraph 17 of Advocate Jiba's affidavit. Where the sentence says, additionally, Mr. Danikas has revealed some of the information that he has provided.
If I may comment on that.
So what I'm putting to you is that it cannot be the case that it is only today that you are aware of the existence of the video footage that supports Mr. Danikas's version.
My understanding is that what I said is that I had not viewed this video. If I'm not mistaken, and I do, the de Kock report also refers to this video and them having looked at it at the time. I need to look at it to confirm that, but that seems to be my recollection. But what I said is I had not seen this video before today. Chairperson, I can quickly go through this report and try to find it. Otherwise, it will be another matter that I can just point out on Monday in the interest of time.
And see, the problem, Advocate Batoy, is that my question is simple. The fact of the existence of the video footage was known to you for a long, long time. It cannot be correct that it is only known to you today. That's the only point I'm putting to you.
No, that is correct. Today, I view it for the first time.
Yes, but the fact of its existence has been to your knowledge for a long time.
That is correct.
Yes. Now, Inspector Danikas continues at 516 when he says, I have witnessed human rights violations, inhuman and cruel treatment.
Sorry, where are we now?
Page 516 of file 2. Now, at page 516 of file 2, Mr. Danikas continues with another video. Says, I have witnessed human rights violation, inhuman and cruel treatment of dying suspects, as well as crime scene tampering in the presence and under the direct command of General Boyce. A video was submitted as evidence in support of my claim. I have witnessed body tampering on a crime scene, as well as the removal of police spent cartridges on a crime scene under the direct instructions of General Boyce. We asked Mr. Danikas for the video that is referenced here, and he gave it to us, and I would like the attorney to play it. So, Madam Chair, before to know what we are watching, according to Mr. Danikas, this was a scene where an alleged suspect had just been shot, and it was before he died. And the two people you will see is Mr. Boysen himself and another person called Miss Sonekas, who was a police officer.
When somebody's calling him. Sponge. There's one afterwards. I don't think it's laid out. Man. Hey, don't be fucking down.
Just stop. The person whose feet are kicking in the air is the alleged suspect who had just been shot. It continues. Go to the next one. No, it continues, Madam Chair.
Wat keep your focus, man, because it's got some crowding. But Rani, you got some water. Just put a bit of water on it. Just put blood on me.
What the witness will testify and say is that before that alleged suspect could die, he repeatedly asked General Boyson to call for medical assistance. General Boyson refused. That gentleman, Madam Chair, with a black shirt and white pants is General Boyson.
Finished. Was hij ook heel goed? Finished, ja.
Shame, she only had the ambulance, that's so long.
Shame, we need an ambulance quickly.
Shame.
We need an ambulance, sorry. Director, we need an ambulance quickly.
My dog is stressing something now. If he gets another.
So after the death of the suspect, only then did General Boyson call for the ambulance. Now, this narrative, Madam Chair, is all contained.
Sorry, before you move on, there was a female voice. Who is that female?
I'm going
Do
to
you
tell you now. If you go to page 491 of file 2, and killed in the car, and the other was injured alive. Was in great pain and bleeding heavily. Major General Boyson said to me that they would call the ambulance and the Independent Complaints Directorate only if the second suspect died. So everyone waited around the second suspect to succumb to his wounds. I was able to use a video camera to record the crime scene in the presence of Major General Boyson and the rest of the officers involved in the shootout. I was always allowed to record crime scenes for the unit, and later it became clear that this is how journalists were bribed, by giving them my own photos as exclusive publications in exchange for favorable stories. But I came to the conclusion that they wanted the films for their own private collection as well. That day, when I realized that the robber would die, I focused my camera on him, so I would later have a recording on how the unit left a suspect to die. Later in 2009, I posted this video on YouTube. I was also instructed by Mostert and Olivier to collect from the floor a number of spent large caliber cartridge casings. After I put them in my pocket, I handed them over to Mostert and Olivier, as they requested me to do. File suspect Malvin Mann dies. That's the file we've just watched. When I told Major General Boyson that this was wrong, he became aggressive towards me and told me that it was not Cato Mano's duty to provide medical care to the criminals. Paragraph 25. The suspect died after a few minutes. I requested Major General Boyson to call an ambulance 3 times before the suspect died. This can be heard in the video. Later, I was informed by Major General Boyson that the driver of the police car with which the robbers escaped was a police informant and had given information at Cato Mano's office for the planned burglary, and that he had left after he had dropped off the suspects at the house that they intended to break in. The suspects then were shot and killed by the unit. The point really is this, Advocate Batoy. We have not just unsigned statements. We have the original video footage recording the activities live by one of the men who was involved in the execution of suspects. And you never watch it, and yet you claim that there was no evidence.
I said there was no evidence to support racketeering charges. I have to emphasize that. And as I said, if I'm not mistaken, the de Kock team do refer to the videos that Danikas refers to in his statement. And I need to look at the statement or the report, as I said, to come back to that. So again, there was nothing at all untoward about a national director not looking at all of the evidence when you appoint an experienced team to look at it. And I also want to make the point that, I'm not saying that General Boyson is an angel. The fact remains that when we charge people, we must make sure that we meet the standard of proof required for those particular charges.
I mean, I'm finding that very difficult to understand. Suspects, if they are suspects, should not be killed by the police. Do you accept that? They should be arrested.
I agree.
Yes.
Completely.
Now, the exceptional instances where shooting may be justified is where there is a direct threat to the life of the policeman, correct?
That is correct.
We've just witnessed a suspect who poses no threat to anyone because he has been shot. And we have a witness who says, I told them to call an ambulance. They refused. And then they said, we must wait until the witness dies because it's not our job to provide medical care. Is that acceptable according to you?
No, it's not. Not at all.
Yes. Madam Chair, I want to thank my attorney and release him, and to notify the panel that the time is 1 o'clock.
Yes, indeed. Indeed, it's a lunch hour. We will take an adjournment until Monday, 9 o'clock. And Advocate Batoi, remember you are still under oath. No discussions with anybody about this matter.
Understood, Chairperson.
We adjourn, and please remember to identify those aspects in respect of which Advocate Batoi needs to reflect so that she can finalize her testimony, at least in regard to those aspects when we reconvene on Monday.
Noted, Chairperson.
We will adjourn. Thank you.